Thank you so much, gentlemen. And right now we're going to welcome our next guest. It's Ann Reinke, she is the president of TIA, Transportation Intermediaries Associations. Ann, always good to talk to you. How are you today?
Michael, great to see you. Thomas, nice to meet you.
The pleasure to meet you as well.
So what's on your mind today, Ann? What's going on?
Well, I'm sure you all are observing the confusion over now. The Supreme Court denied cert in the AB5 case, the California Trucking Association case. And so there's some protests, as you know, at the Port of Oakland, and owner-operators are trying to determine, are they going to be able to maintain their own independent livelihood, or are they going to have to become employees of a larger trucking company? The same issues are arising for brokers. Are we going to be now an employer for purposes of this law or not? And obviously, there's already a truck driver shortage. Is this going to make it far worse? Separate and apart from the immediate issues to the supply chain of having a protest outside of the port itself, where I think it's sort of slowed to a trickle as to the incoming freight and the containers that are put there.
That's a really interesting perspective, and explain that a little more to me, because one of the solutions that was being thrown about was, well, just, throw brokerage at the end of your company title and you can broker these guys and you're around AB5 and you're all good. But that's not what you're thinking. You're thinking this is a big situation where you could potentially be brought into this, right?
Well, yeah. And so looking at the language of this, as they call it, the three-prong test, the ABC test, Section B is so broad that it's really hard. It's hard to understand if that would apply. So the language is essentially the worker performs work that is outside the usual course of the hiring entity's business. That would exempt them from the law and being classified as employee. Well, what does that mean? I mean, so a brokerage, their entity is moving, arranging the freight transportation, and the owner operator is moving that freight. So is that outside of the entity? It's hard to know exactly what they mean, because it could be interpreted in so many different ways.
Yeah, physically moving the freight or facilitating the movement are two different phrases, right?
Exactly.
This is where Oxford commas become important, in my opinion.
Right. It's the definition of what is. It's like we've got to really understand exactly what it means. So, everyone who is affected in the freight industry is looking at this to determine exactly what the implications are. I know the owner operators are saying, first and foremost, we have a successful business model. Why are you trying to destroy it? And then the larger carriers are saying, this is not what we signed up for. We already have a deficit. Is this going to make it worse? And so that really is, we're all sort of trying to collaborate and figure out exactly what the implications are. Because as you know, there's been an injunction against the enforcement of the law since 2020. So now it's like, all right, things are getting real and we got to figure it out.
I remember back in my experiences as a broker, you work a lot with owner-operators. When you start out as a carrier rep in some of these brokerages, the first thing you do is you try to find owner-operators to work with because it's harder for them to gain access. Does this mean now, with the potential, now that the Supreme Court is not going to see it, the status of owner-operators in California, is this going to have a huge impact on these brokers with AB5? If you have a customer that does things on the ports and you have drayage customers as a broker, because that's where you can make good money, you do a lot of drayage, you do a lot of volume, are brokerages prepared from even a compliance standpoint to handle the impacts of AB5, or are we kind of caught off guard here?
Yeah, I mean, Thomas, this is why they pay you the big bucks, because you ask good questions. I mean, that's exactly the thought process that we're having, which is, are we going to have to get out of California altogether if we're a brokerage? How are we actually going to be able to de facto do business, especially if we have laws that are only, specific to that one state that don't affect the rest of the country? Now, we're obviously concerned about copycat legislation in other states, and certainly there are states that are looking at that. But really, if we just think of the instant case of California, all of these are concerns for us because we have an incredible cadre of owner operators that we rely on that make us successful. And in return, they find us to help them because we provide them the contacts with shippers that they may not already have and the business that they need. Also, we act sort of as their sales force and we provide them, money faster. So there are mutual benefits to this relationship. And so what happens to that going forward?
Yeah, I mean, so these problems and what you're discussing right now, and how are you going to do business, and how are you going to do that de facto staying out of California, et cetera, don't these prove the point that this is national interstate commerce, and therefore it is a violation and should not be enforced? I mean, doesn't all this argument prove that point?
Yeah, and I've read something to say that their law somehow is not preempted by interstate commerce, and I don't know if I quite understand that or agree. I
don't
know
agree with it. I think it is.
I agree with you. I think it is too. How could it not be? Particularly when most brokerages, there's some that are just specific to one state, but most of them are not, and most drivers are not specific to one state. They go all over. That's the essence of the job.
It really is. So does the potential application of this towards intermediaries, does it become more dangerous for those that are asset-based brokerages or asset-based carriers that have brokerages? Are they more susceptible to this law, you think, than those that are just strictly non-asset brokerage because of the difference between physically actually moving freight and the facilitation thereof of the transaction?
I think they're the ones who are feeling the most worried first, which is not to say that the other brokers will not, but they are absolutely feeling the heat first and are the ones who are most engaged. I think ultimately we all are going to wake up and recognize, good Lord, what does this mean for our business? But yes, you're absolutely right. They're at the point of the spear.
Looking at the last question here while we have a little bit of time, moving forward in next steps. A lot of time in the regulatory environment when you're lobbying and stuff, it comes from the national, the FMCSA, the federal government, Congress. I feel like we're kind of caught off guard. A state has decided to take point and now it's influencing the entire nation. What are some next steps in regards to AB 5? How would you as the TIA get out there and try to help enact some change? Do you change your strategy? Do you bring a bunch of people to California? What would be some good next steps?
Right. So we have a lot of smart members who are absolutely looking at that. We've developed an AB 5 working group to look at what our options are as brokers. And then there are companies who are members of ours who are looking at trying to establish a nationwide coalition and what that would actually effectively mean. So does it mean from a legal perspective, is there something that we could do with the CTA case? I don't, probably not, but you don't know, right? So let's examine, is there anything left? Is there one more arrow we can shoot in that particular legal case? From a legislative and lobbying case, I talked about copycat legislation. Is there a lobbying effort now that we can take state by state, particularly those states that have already mentioned their interest? I know when I think about that, I think of New Jersey and Illinois that are looking at things like this. And then from a federal perspective, also lobbying the PRO Act, right? We don't think that's going to go anywhere, certainly not this Congress, probably not next Congress. But it's one thing to say it's not going anywhere legislatively, but as we all know, and what you mentioned is things that could be ideas that don't go anywhere legislatively could somehow surreptitiously get adopted with regulation through guidance and other things. So we obviously have to be watchful for that as well.
Yeah, absolutely. And I would think that and I know it was a negative, or the last question, but one last comment is just, it would seem to me that the dangers and the issues from the TIA's perspective are there regardless of whether this impacts you as them being an employer-employee relationship. Even if you were to get the answer that would confirm the positive for you, meaning they're not, it still affects your ability to get capacity and moving things. So it's still in your interest to not have AB 5. And I think a lot of people's interest, to tell you the truth. I'm on your side on this one. Right here. And thank you so much. And we'll talk to you again. Good luck with this. Hopefully we get some clarity and we get some, in my opinion, some common sense and intelligence applied to this and do the right thing. So anyways, thank you so much. Have a great rest of your day, Ann.
Thanks, guys. Appreciate it.
Right now.